Hello and welcome. I'm Peter Afrasiabi, host of The Curious Lawyer, and this is the Curious Lawyer Bill of Rights series, Third Amendment. Now, The Curious Lawyer, for those of you who have watched some of our other programs, and I encourage you to watch them all because they're fun, interesting, edutainment type walks down different paths of the law, off the beaten paths, things that aren't central and core necessarily to what you're practicing, so they're not stressful in that sense. You're not having to learn the latest on procedure or how to get evidence in or all the things that you as a copyright lawyer need to know about copyright law and you're not sure you're up with, so you're manically taking notes and you're attending the CLE in some state of stress. This is fun. It's educational and entertaining, and it's a great way to broaden your horizon as a lawyer, to broaden your knowledge lens, so to speak, which actually then gives you arguments and ideas and metaphors and things you can work with in your cases. And so it's a great educational program for us as lawyers to explore some of these Curious Lawyer series and be able to, when you show up at cocktail parties or other events, be hyper knowledgeable about all the little arcane things in the law that people assume you know as a lawyer, but maybe you don't right now. So check out some of our programs. We've done dog law. Everything you ever want to know about dogs and how they relate to you, it's there. CIA law, presidential pardon law, a program on crazy weird laws. You just want to see all the crazy weird laws that are out there. Even we've looked at Yellowstone National Park and whether you can get away with murder in Yellowstone National Park. So let's get going today in our Bill of Rights series, which gives you a chance to spend an hour on each of the first 10 amendments to the Constitution, our Bill of Rights, and really become knowledgeable about them in a way that perhaps you haven't before. And today's fun focus is on the Third Amendment for this reason. You've probably never thought about the Third Amendment. It is one of the least known amendments, and it is the least litigated amendment out of the first 10. And so it's a fantastic place to start this program and for you to know that 60 minutes from now, or now maybe 55 minutes, you will know everything there is to know about the Third Amendment. I promise you that. That's my guarantee. And at the end, you're going to see it. So let's get going. We're going to start, of course, with the text. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Seems somewhat straightforward, right? Well, let's take a look then at what we are going to address today as we explore this idea behind the Third Amendment and what it means when it talks about quartering of soldiers in homes without consent and whether it has some penumbras to it and some broader breathing room to it to give rise to different claims. So, what are we going to address? You see here on our issues addressed slide, we're going to try to get through the following, which makes it very contemporary and fun because we're even going to touch on COVID in a second. So, the first thing we're going to look at is what is the substantive nature of the Third Amendment? We will then look at the historical scope and rationale, the purpose, the goal, the raison d'etre of the Third Amendment. We're going to look at case law on the scope of the amendment's phrase soldiers, because that's the phrase that ends up being litigated. What is a soldier? Is it a federal soldier? Is it a National Guard? Is it a policeman, a security guard? What's a soldier? And we're going to look at whether this Third Amendment, does it apply to the states? Because remember, the Bill of Rights applied to the federal government, and then when the 14th Amendment was adopted through the incorporation doctrine, some of the Bill of Rights was incorporated and made applicable to the states. One of the questions we're going to look at as we explore and remind ourselves about that incorporation doctrine from con law in law school or the bar exam, one of the things we're going to explore is, has the Third Amendment been incorporated or not? I'm not going to tell you right now. You got to watch and find out. We're also going to look at the privacy zone issue that has arisen in case law in terms of the Third Amendment and whether the Third Amendment's language, although textually focused on soldiers and quartering, whether it really defines and gives rise to these important ideas about what privacy rights we as people have vis-a-vis federal government encroachment. And here's a fun fact out of the gate for you. You all get to use contraceptives in part because of the Third Amendment. Who knew? I bet you didn't. I didn't know either, but now you do. Third Amendment's a great amendment for all of us for that reason then. We're also then going to look at current issues within the Third Amendment jurisprudence, and novel arguments that have been pressed for the amendment in contemporary society. And although it is unequivocally the least litigated of the Bill of Rights amendments, fascinating arguments are percolating about COVID mandates, COVID rules, and much of the litigation and legal issue melees that have come out of COVID and our societal response and the legal regime's response and means of addressing COVID in modern 21st century society. But some of this sort of touches the Third Amendment, and it's created Third Amendment type arguments and issues that are now percolating out there. And so it's a fun way to explore not just a historical understanding of the Third Amendment, but how this amendment that is the least litigated amendment may start becoming a more litigated amendment. So let's get going, and I want to start again with the language. And you won't have this language up in front of you all the time, but if you have your handy little U.S. Constitution pocket guide, which I know you all have and have on your desk, whip it out. You can open it up to the Third Amendment and put it there, or you can go to Google and open another browser on your other screen and put it there. But in any event, let's just take a refresher on the Third Amendment's substantive language. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So that's the language that we're playing with today. And let's get going on our next slide with the historical context to this. And so you see here we have some good information that gets us to the legal background that we have to confront in terms of the history that helps illuminate the interpretive questions we have about the Third Amendment and what it means. And so the time's concern, if we go back to the 1600s and the 1700s, both in England and actually here, obviously in the colonies in our nascent republic, was heavily revolved around the idea of standing armies. And by the time we reached the 1600s in England, there had been centuries of criticism against the crown, the English king, about the quartering of soldiers in people's homes. After conflicts in North America, including King Philip's War in the 1670s, New York in 1683 became the first colony here to actually provide legal protections against quartering. So this quartering problem that had afflicted the English in England had crept over to the colonies because of the king's sort of imposition of will on the American colonies. And so New York said, no, in our colony, our place, we have now enacted a law that provides legal protections of some kind against quartering. Now, in the French and Indian War, then in the 1700s, which lasted from 1754 to 1763, colonists were worried that quartered soldiers could infect them with smallpox. And this was a disease that the British soldiers were deliberately transmitting to the Native Americans. And so this is why it's particularly interesting if we start thinking about today's COVID with this highly transmissible disease. And this is where we get an intersection of disease, COVID, with the Third Amendment. And so historically what was happening is there was this concern, oh my goodness, if we are forced to have soldiers quartered in our homes, soldiers who have smallpox because they're trying to wipe out Native Americans with smallpox, those soldiers may pass it on to us in our homes. We don't want communicable diseases brought into our homes, our private spheres, our space, by quartered soldiers. And so we get an intersection then with the Third Amendment and disease. Fascinating. So what was going on then, big picture, as we start getting closer to the Declaration of Independence and quartering acts that were passed in order to impose problems on the colonists, is this idea that the English colonists were relying on local militias more than professional soldiers. And so they didn't like the idea that soldiers were being compelled to stay in their homes. And this then leads us, as this sort of quartering is going on, to the Quartering Act of 1765, where the British Parliament enacts this law and demands that American colonists bear the cost of feeding and sheltering British troops stationed on our shores. And so the act provided that if there was insufficient room for the soldiers in the barracks, they could be forced into inns, livery stables, alehouses, people's personal private homes. And so the result obviously was a bunch of unhappy American colonists, and the rest is history. We could stop there, but let's not get ahead of ourselves, and we'll keep walking through the history. We have the Quartering Act of 1774, where the city of Boston provided barracks for British troops only on an island in Boston Harbor from which the soldiers couldn't move quickly to the city in case there was an uprising or disturbance by the colonists. And so this sort of mechanism employed by Boston was to say, okay, fine, you can quarter some troops. We're going to put them on an island, and that enables us to engage in our revolutionary behaviors, and your troops can't really interfere with them. Of course, the king's not happy about that, so he passed a new act that said British commanders had every right to quarter their troops wherever they wanted, including in the homes of the colonists, and no doubt in the homes of the revolutionary colonists. This, of course, was one of the intolerable acts, the famed intolerable acts that our founding founders of the United States listed in terms of the terrible things that the king had done that are simply unacceptable and required the need for a new republic, a revolution, a new country, and sort of part ways with the old ways. And so one of the intolerable acts, as quoted and framed by the founders, was that he has kept among us in times of peace standing armies without the consent of our legislatures, quartering large bodies of armed troops among us. This then, of course, is why this idea of standing armies was of such a concern here, but even for English citizens in England who were being subjected to sort of abuse by it. But particularly here, it was one of the intolerable acts and the founding animating issues that led to ultimately Declaration of Independence, the Constitution, our country, and the Third Amendment. And so now let's take a look, before we get to the Third Amendment, at the Declarations of Independence, because one of the things that was going on is before we even got to our national Declaration of Independence, we had colonies drafting their own declarations of independence for their colonies. And one of the central themes as you go through the historical record and look at the different colonies' own declarations of independences was, again, this standing army thing and this quartering thing that was so troublesome. And so here we have, we can quote Section 21 of the Delaware Declaration of Rights that was drafted in 1776 also, that provided, quote, "No soldier ought to be quartered in any house in time of peace without the consent of the owner, and in time of war in such a manner only as the legislature shall direct." Massachusetts, Maryland, other colonies, they had similar ones. And so the Declaration of Independence then ultimately registered this complaint that the king, quote, "has kept among us in times of peace standing armies without the consent of our legislatures." And so that was one of the fundamental planks that required revolution and the formation of the United States and this new republic that we all live in today. And so from this, we can understand our history, which starts getting to our interpretive questions. And so you already saw a little bit of the preview about the concern, one of the concerns of standing armies, not just being invading privacy, and we're going to talk about privacy, but also transmission of disease and what that means and whether one can do that in that zone of privacy. Now, let's start talking about actual cases. Supreme Court interpretations? Well, it turns out no case has ever gone to the Supreme Court to squarely address the Third Amendment. It's been mentioned a few times in dicta on property rights and privacy rights, but there's never actually been a straight up, squared up, boom, Third Amendment analysis. Someone's been quartered, here's the Third Amendment, is it okay, is it not okay, and what does the Supreme Court say? No such case has ever made its way to the Supreme Court. Circuit court cases, trial court cases have been Third Amendment arguments, but nothing to the Supreme Court. So here we have, since we haven't had much directly from the U.S. Supreme Court, I can give you a quote from the 10th Circuit in 2001 that says, quote, "Judicial interpretation of the Third Amendment is nearly non-existent." That about sums it up. In terms of the interpretive nature of what we can discern from this, there's almost no case law. And by the time you're done with this program, you will have seen every single case. And that was Custer County Action Association versus Garvey, 256 F. 3rd, 1024 at 1043, coming out of the 10th Circuit in 2001. So let's talk about the first case we have out of our scant case law. What is a soldier? We're going to look at this and answer this from Engblom versus Carey, 677 F. 2nd at 957. And this is a Second Circuit case in 1982. And so here are the facts. We have some state correction officers, folks who are working in the local prison. They go on strike. And at the time, they were living on the actual state grounds in order to do their work near their prison. So in other words, they worked on the prison as state correctional guards, and close by there was correctional housing, for lack of a better word, student housing. There were basically apartments that the prison workers would live in order to be close to their work and do their work. But there were actual apartments they had. And when they got their paychecks, money was deducted as rent. It was literally listed as a, quote, tenant expense. And so it wasn't just kind of a gift, oh, you can stay here. They're paying rent to stay in the location. But they go on strike. And so the governor now has to deal with this fact that there's a prison, there's a whole bunch of prison inmates, and we got a whole bunch of striking correctional guards. Obvious problem. The governor, in turn, calls out the National Guard. And so the prison officials who were running the prison, who now had a bunch of correctional officers who weren't at work in the prison and were hanging out in their apartments, now the guys running the prison say, okay, we got a problem. We got the National Guard showing up. They got to go into the prison and replace the correctional officers. We got to put the National Guard somewhere. Where are we going to put them? Oh, we're going to put them in these apartments we have for the people. So they kick out the correctional officers. And these people said, wait a second, it's my home. You're kicking me out and you're putting in the National Guard. And so they brought a claim that putting the National Guard into their apartments was an invasion of their homes within the Third Amendment. And so they were having, soldiers stationed there in violation of the Third Amendment. And so this then requires, on our next slide here, you see the Engelblum Court, and this comes from the Second Circuit again, to figure out what's a soldier. And so here's the sort of basic rules that were adopted by the court in terms of getting to the bottom of this Third Amendment claim as pressed by the prison guards. Number one, the Third Amendment was designed to assure a fundamental right of privacy. And that's an important principle and premise that the court adopts. The court also said that a rigid reading of, owner within the Third Amendment to, apply only to sort of fee simple owners would be wrong, and it would end up disadvantaging those who may be renters and whatnot, and who were perfectly permitted by society to have it. It would allow them to be sort of knocked out of their place and have sort of occupation taken by others. And so that's not okay to limit the rights to be free from quartering to sort of someone who has some fee simple ownership. I mean, or if you have a rental possessory interest in the property, then you absolutely have the right to assert a Third Amendment claim. And sort of, so, the prison officials and the state's response that, oh, you don't own it, not good enough. And then the court held that the National Guard were soldiers within the meaning of the Third Amendment. And so fundamentally then what they held is that these plaintiffs had a Third Amendment claim. And the district court, which had told them, no, you don't have a Third Amendment claim because you don't own, you rent, and because National Guard aren't soldiers, they're just like National Guard. It was too different, I guess, for the district court, was nonetheless rejected by the Second Circuit. And they said, nope, there's a viable Third Amendment claim, go back to trial. So that gives you some idea that soldier has a broader reading than just federal member of the Army per se. It can be the state National Guard type folks who get called out in emergencies to function in sort of the same role as soldiers, quote unquote. Let's take another case. This is a fun case from the 10th Circuit also in 2001. It's Custer County Action Association versus Garvey. It's reported at 256 F 3rd 1024, and it gets at this issue of military planes are flying in your airspace above your home. Does it violate your Third Amendment rights? Do you have, if the military is quartering its troops up in the sky above your property, but, above your property in essence by flying through airspace above you, is that a violation of your Third Amendment? And so what we have here is, a fun, fascinating case involving the following facts. The FAA ends up doing an environmental impact study for this Colorado airspace initiative that was passed. And they concluded that there was a whole range of airspace training activities that would be totally fine to do over a certain range of land in Colorado under the Colorado Airspace Initiative. And that means you're going to have a whole bunch of sort of federal or state military aircraft doing all these sort of training and whatnot in the airspace. There were some plaintiffs who weren't happy. And they said, hold on, all of this airspace initiative stuff, it all sounds great, but it's a bunch of training of airplanes making a bunch of noise over our homes. We don't like it. So they bring a Third Amendment claim. And they said, our home, our airspace, our privacy is ultimately being invaded for military purposes during peacetime without our consent. I mean, it's peacetime here. There's no war going on in Colorado that requires military planes to be doing all of this, and so you need my consent to do it. And so the analysis adopted by the court is as follows, quote, and this is the analytical sort of issue that was sort of being framed and teed up. The crux of any such claim, however, is whether the nature of the asserted property interest falls within the ambit of the Third Amendment's prescription against quartering troops in any house without the consent of the owner. And so that's sort of the obvious interpretive issue that has to be addressed. And so you see on the next slide here, let's talk about the rule that was adopted by the Custer case and then the holding of the Custer case. The rule was that the property-based privacy interests protected by the Third Amendment were not limited solely to those arising out of fee simple ownership, but they also extended to those recognized and permitted by society as founded on lawful occupation or possession with the legal right to exclude. And where that rule is similar to the rule we saw in the prison official case. Where the case fell down, however, was that the court concluded, quote, taken to its logical extreme, petitioners would have the U.S. military seek consent from every individual or entity owning property over which military planes may fly, and then design its training exercise to utilize only that airspace for which permission was granted, or else risk Third Amendment liability. We simply do not believe the framers intended the Third Amendment to be used to prevent the military from regulated, lawful use of airspace above private property without the property owner's consent. It is not reasonable to expect privacy from the lawful operation of military aircraft in public, navigable airspace. You say it by fiat, it is. I mean, what's funny there is if you actually think about the idea that whether the framers intended the Third Amendment to be used to control the military flying airplanes above, it's almost a nonsensical counterfactual. I don't think the founders had an intent one way or another because they never thought about airplanes flying over airspace in the 1700s, obviously. But nonetheless, the court said it, and it is what it is. The military can fly airplanes over your airspace and know that Third Amendment is not going to let you stop them. Let's take a sidebar here and address the next question. Does the Third Amendment apply to the states? In other words, has it been incorporated through the Due Process Clause of the 14th Amendment such that the states cannot quarter their soldiers, state soldiers, in our homes? That's the incorporation question. So, as a quick reminder, if we go back to con law in law school or on the bar, if you don't practice much in the con law area and you don't remember that incorporation doctrine, kind of a cool doctrine, basically the way it worked is this, and that is we start from the premise that the protections of the constitutional amendments, of the Bill of Rights, the first 10 amendments, had only applied to the federal government textually and not the state governments. But they were then applied to the state governments by way of the adoption of the 14th Amendment, and specifically its Due Process Clause, that the Supreme Court and courts have held have incorporated those amendments into and made applicable to the states by virtue of the 14th Amendment's Due Process Clause. So it's sort of reverse incorporation back. And the basic test that has been sort of adopted by the Supreme Court to analyze this incorporation issue of constitutional law is whether the amendment, the rights at issue in the amendment, are fundamental rights, quote, rooted in the tradition and conscience of our people, and thus, quote, implicit in the concept of ordered liberty. If they are, then they're applied to the states via the 14th Amendment. And that comes from the Griswold v. Connecticut case. We'll be talking about it soon when we get to the right of privacy in the Third Amendment, the famous Supreme Court case allowing couples to have contraception and doctors not to get prosecuted for prescribing contraception, in the marital bedroom and whatnot. So in any event, that comes from the Griswold case, a Warren Court case in 1965, and that quote comes from 381 U.S. at 499. And really, all of the Bill of Rights amendments and clauses within those amendments have basically been applied through the 14th Amendment to the states, except for a few. Now, here, obviously, it hasn't actually made its way to the Supreme Court, but the appellate courts, the Second Circuit that have looked at this and other courts have held, yes, the Third Amendment is incorporated via the 14th Amendment and is then made applicable to the states, which is why the State National Guard in Cary, as you remember, when it was called out and the state was sued, the state was unable to take, or viably unable to take, the defense that, wait a second, we can quarter whatever state soldiers we want in someone's home because we're not the federal government. The court said, no, it applies to you via this fundamental rights type test from Griswold. So the Third Amendment applies to the states. That's kind of a good sidebar. Let's now go to 1942, and we're going to go to the Aleutian Islands, and we're going to think about some issues that came up during World War II. And here, what happened is as follows. The islands off the coast of Alaska were evacuated when Japan, during World War II, attacked them. And the U.S. Military came and evacuated the island's inhabitants and put military soldiers in those island inhabitants' homes. And so the people were forcibly removed from their homes on the islands, taken elsewhere, and U.S. soldiers and troops dropped down into those homes and lived there and took over the homes to fight the war effort. Now, there was no litigation that came out of this at the time, but decades later, the issue percolated up through the political channels in terms of the wrongdoing of doing this to people. And what happened is the U.S. government eventually in 2006 admitted the wrongdoing and said, this is wrong what we did. And they agreed to pay damages with $5 million in funds that would be then made available to descendants from the Aleutian Islands of the people who were forcibly removed and had soldiers stationed in their homes. And so this is a quote from the statute. In addition to payments made under Section 205, that's another section of the statute, the Secretary shall, in accordance with this section, make per capita payments out to the fund to eligible Aleuts. The Secretary shall pay, subject to the availability of funds appropriated to the fund for such payments, to each eligible Aleut the sum of $12,000. That's just basically the statutory recognition that we're going to pay money for what was, at root, a violation of the Third Amendment in part, as well as sort of other wrongdoings. But certainly a Third Amendment violation was sort of the tip of the spear being advanced in terms of some of the wrongdoing that occurred, or an argument for the wrongdoing that required financial remuneration to be made to the descendants. And so it's a fascinating statute that brought closure to what was a Third Amendment violation in 1942. Arguably, it was a time of war. Who knows? But nonetheless, it was part of what was going on in terms of what happened to these people in those islands that were, remember, off the coast of Alaska during World War II, and before statehood for Alaska. Now let's take a look at some other claims that we can say are far-fetched claims that people have tried to bring via the Third Amendment to stop litigation or stop process or deal with the government or find financial remuneration, you name it. So let's take a look, and we're going to run through some what I've called somewhat far-fetched claims to help illuminate for you and close out your full knowledge of the Third Amendment as it's shown up in litigation. Securities Investor Protection Corp versus Executive Securities Corp. This is at 433 F Sup 470. It's from the Southern District of New York in 1977. And there was a contempt proceeding by the SEC, and the party claimed that the subpoena violated the Third Amendment. It was a little vague. I mean, what was the exact argument? ... It was entirely unclear. The court was somewhat confused about how a subpoena to gather information was violating the Third Amendment, but it was, perceived perhaps as advanced that it was somehow, invading into the zone of privacy or something like that. It wasn't fleshed out, but it was summarily rejected. And it's kind of a funny quote from the court because it says, it's difficult to understand how the subpoena violates plaintiffs' rights under the Third Amendment, or moving parties' rights under the Third Amendment, which reads in full as follows. And then it quotes the Third Amendment. And that was basically all the court said. It was a sort of out of hand, swat away, we're done, you're wasting my time. So the party didn't actually flesh that one out to have any more detail. Let's now go to Minnesota in 1972. And on the next slide, you can see the case of Jones versus United States Secretary of Defense. And it's reported at 346 F Sup 97 from the District of Minnesota in 1972. And here we had a claim by Army reservists that a parade order, an order for them to participate in a military parade, and the reservists had to come out, put on their uniforms, go through the parade in public. They were like, I don't want to do a parade. I don't want to participate. And they brought a claim saying that this forced parade basically violates the Third Amendment. And what the District of the Minnesota District Court held is that no, Army reservists can be required to attend military parades, and it is not a violation of the Third Amendment to make you attend and participate in a military parade. You're not being forcibly quartered into a parade against your will or something like that, as the claim was. Let's now come, of course, to California, where I live. And, you know, if you want far-fetched claims, you've got to be in California at some point in the program. This comes from the Southern District of California in 1951, and it's the case of United States versus Valenzuela. And it's reported at 95 F Sup 363 with a pin site at 366 if you want to get right into it, if you want to go do some fun research after here. But in any event, this is what occurred in the background, and these are the facts of the case in Valenzuela. Plaintiff was a soldier in Korea, and he wanted to enjoin the curtailment of the rent control laws. And those rent control laws had occurred by virtue of a federal act, during the war period, and they were coming to an end. And there was a termination then of price controls also from that post-war era. And the plaintiff, soldier over in Korea, basically claimed that, quote, the 1947 House and Rent Act is and always was the incubator and hatchery of swarms of bureaucrats to be quartered as stormtroopers upon the people in violation of Amendment 3. It's such fun language. You got to enjoy it. I suspect half the population probably does believe that those in D.C., maybe all the population, are an incubator and hatchery of swarms of bureaucrats. Maybe they are swarms of bureaucrats. But nonetheless, he claimed that this curtailment of the Rent Control Act and whatnot was hatched up by a bunch of bureaucrats, and it was being quartered as stormtroopers upon the people. The court couldn't even understand the argument, actually, and rejected it. And so this is another quote. This challenge, to quote from defendant's brief, has not been heretofore made or judged by any court, insofar as our research discloses. We accept counsel's statement as to the results of his research, but find this challenge without merit. A very polite way of saying, what on earth are you talking about? So you see, Third Amendment jurisprudence, what we find is it is a hatchery and swarm of far-fetched claims. Now, this brings us to the right of privacy and the Third Amendment. And this idea that can you, from textual language that's only talking about soldiers going into homes, can you divine from that something more fundamental, something more elemental, right? This root idea that the reason soldiers can't be put into our homes is because those homes, our homes, we have a zone of privacy. We have a privacy right. And so it's not just some military conscription thing that soldiers can't come in, but other things can come in, totally okay. It's more reflective of the idea that, no, there is this zone of privacy that we all possess, a fundamental right. And soldiers in particular, because it was that time concern, was identified in the Constitution as not being able to come in absent a proper process. But there's also a broader zone of privacy that can find recognition by the federal government, i.e. federal courts, the third branch of government, through litigation. And so, as it turns out, the only Supreme Court mention really of the Third Amendment is in actually the context of the individual's right of privacy. And so this, of course, opens the door to the idea that there could be a new expansive reach of the Third Amendment as part of the bedrock explanation for privacy rights. And so this is what's going to bring us now on this section to Griswold versus Connecticut, case I'm sure you all know and remember. It's reported at 381 U.S. 479. It's from 1965. It's probably the high watermark of one of the high watermark cases of the Warren Court in terms of the liberal block of the Supreme Court and the adjudication of cases and the rules of law that they were adopting and holding. And so this case involved some defendants who had been convicted and punished under Connecticut General Statute 53-32. And they were punished for dispensing birth control devices to married couples. And the statute prohibited doctors and the directors of the medical clinic from doing that. And so, bottom line, married couple comes along, says, hey, I want some birth control. Doctor gives them birth control. Police come and arrest the doctor and say, you can't do that. It violates Connecticut law. You're not allowed to give birth control to married people. And so that, of course, led to a piece of litigation in the Connecticut state courts. And in the Connecticut state courts, they made the argument, the medical doctor and director, that, this violates the 14th Amendment and due process. And, we have the right to prescribe this type of birth control, and you have no right to tell us that married people especially can't get birth control. And so the Connecticut court, rejected the claims, trial court, appellate court, and then ultimately the Connecticut Supreme Court all said, no, the state statute stands. The state has the right, has an interest, a sufficient interest in curtailing this in terms of maintaining decorum, morality, these kinds of just kind of law and order, decorum, morality, maybe we kind of avoid other problems, kind of an inchoate set of interests ultimately, but were sanctioned as being legitimate. So the case was taken to the U.S. Supreme Court. U.S. Supreme Court grants cert, and this is the quote. I mean, the issue fundamentally before the Supreme Court was as follows, and here's a quote from the case which lays it out. The present case, then, concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. And it concerns a law which, in forbidding the use of contraceptives rather than regulating their manufacture or sale, seeks to achieve its goals by means having a maximum destructive impact upon that relationship, i.e. the relationship of, the married people, the doctor-patient relationship, and sort of the state kind of mucking around in our bedrooms. So, oral argument at the Supreme Court. We are incredibly lucky, really. I mean, we're so lucky to be living in the technology age. I always tell my kids, they can't even imagine that there could be things before the technology age. And so we actually have recordings of this case, even, believe it or not, that we can actually listen to. And because of the wonders of the internet and YouTube, we actually are able to hear them. They're not sort of lost forever in some arcane library, and you get to watch this program over the internet, and now you get to listen to part of the actual argument, Griswold versus Connecticut. It's a fascinating exchange to listen to for the next several minutes, where you get to hear the justices of the Supreme Court pressing the advocates, especially the Attorney General for the state of Connecticut, to understand what exactly is the state interest here. Like, why exactly do you need to sort of, be in Peter's bedroom? What's going on here? And so that is what we're going to listen to now. Listen to it, enjoy it. It's a fantastic opportunity to sort of get a piece of history alive, and I'll be back with you in a few minutes.
Mr. Clark, what you're touching on now leads me to ask, what is the purpose of this legislation in Connecticut? Your basic argument in your brief, and so far in your oral argument, is that this is well within the so-called police power of the state of Connecticut. And what is its purpose?
Well, if Your Honor, please, I think its purpose is
to increase the population of Connecticut, right, or to impair its decrease, or is it what?
If Your Honor, please, I do not hold that it is to increase the population of Connecticut. I don't think that this is we could make this claim valid.
So what is it? What is the purpose?
I think it's to reduce the chances of immorality, if Your Honor, please, and I use the words immorality here in a broad sense. That is, in one way, to act as a deterrent to sexual intercourse outside of the marital relationship.
Well, the trouble with that argument is that on this record, this involves only married women.
That is correct, Your Honor.
So how can you make that argument?
Well, if Your Honor, please, I think that on this record, that the statute is a valid exercise of police power.
Well, for what purpose?
And if Your Honor, please, on this record, that there is a distinction, and there has to be a distinction between birth control and the use of contraceptives. That is to say that all contraceptives involve birth control. But in order to practice so-called birth control, one does not have to use contraceptives. And that the state is able to take this position and take this distinction, that there are, if it be said, well, should married people be allowed to use these devices?
Yeah.
Is not the state going too far? I think the state can answer to that there are other methods available to married people.
Well, for what purpose under its police power? Assuming we're dealing now with married couples.
Well, if Your Honor, please, going back, Connecticut in the Nelson case cited the Byrne case in New York. And one of the reasons cited by the Connecticut court and the Byrne case was that it would not be, as a matter of fact, it would not be improper for the legislature to consider that Connecticut, as any state, has a right to look out for its own continuation. This is the population argument. I personally am not too happy with it. But
Well, what argument are you happy with?
I think, if Your Honor please, the only argument that we can honestly say is that this is a question of pure power.
Well, do you suppose the state
power.
of Connecticut could prevent marriage?
I think the state of Connecticut could prevent marriage on certain people, certain groups. Yes, if Your Honor please. Between idiots, say, or age in marriage, I think, if Your Honor please, that...
But surely you'll agree with me they couldn't, I should think you'd agree with me that the state of Connecticut should say there'll be no marriages contracted in this state. Be no sexual intercourse of any kind, married or unmarried.
I agree with you.
Well, now, what is the police power purpose of Connecticut in telling married people, two people who are married to each other, that they cannot use contraceptives?
Well, I think, if Your Honor please, it's to preserve...
what kind of morality? What moral purpose is
Well,
that?
if Your Honor please, it is not unheard of that the use of contraceptives themselves would be immoral. Certainly, this is a view that has been prevalent in history right up to the last few years in most groups. In Connecticut, I'm citing the brief of our opponents in one instance of the number of Catholics and Orthodox Jews in the state. If you were just to put it on a numerical basis,
Well, you'd have quite a different case if the state of Connecticut compelled their all married couples to use them. That's not. That's when you'd run into the argument you're now making, that this violates the religious precepts and beliefs of certain groups.
This is true, but if Your Honor please, it also would be more difficult for the state to control the result of what you might call dissolute action. That is, fornication and adultery. That's what it's there.
Well, I thought you and I had agreed that isn't involved here. We're dealing here with, by definition, and on this record, with advice and the furnishing of devices to married women who ask for such advice.
Well, if Your Honor please, I think what we have here, that is true. We have here a center being used, and the witnesses that the state used in this case were, in fact, 3 married women.
Mr. Clark, inquiry, on page 15 of your brief, I don't know that I agree, but if you might provide an answer by reading what your court said in State versus Nelson. Doesn't sound like a very lofty attribution to married people, but that's the reason your court assigned. Page 15, State versus Nelson. You look at the next to the last paragraph.
Your Honor, please, that's what I was trying to get out, and I must say that I did rather poorly.
That is the reason your state, I take it, assigns that morals are involved.
That is correct, if Your Honor, please. The court held in Nelson, it, meaning the legislature, was not precluded from considering that not all married people were immune from temptations or inclinations to extramarital indulgence. And I think, if Your Honor, please.
That is the moral ground, then, upon which presumably your court has sustained this legislation under the police power.
I think it is. I think
that's the ground on which you're relying.
That is correct.
Okay, so you heard it. It was fascinating, and you saw the grilling there at the end that ultimately, very politely, but the grilling really that the state's lawyer was under to come up with a good explanation for what it is. What is the idea of general morality and public policy, and what is it you're trying to do and achieve to make sure to justify this kind of an imposition on people? And when it boils down to, we don't want to incent, women to go out and cheat on their husbands because birth control is going to be available. You just look at it and just go, yeah, okay, you're in trouble when that's your argument. And so that was ultimately the Supreme Court then, after the oral argument, they go to decide the case, and they ultimately reject it. And so here's where we get to the Third Amendment. And here's the quote where we really now have the Supreme Court for the first time talking about the Third Amendment. The foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. The right of association contained in the penumbra of the First Amendment is one, as we've seen. And here's the kicker for us in today's program, the Third Amendment. The Third Amendment, in its prohibition against the quartering of soldiers in any house in time of peace without the consent of the owner, is another facet of that privacy. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment, in its self-incrimination clause, enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. The Ninth Amendment provides the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So for us, the most important language here is that this idea that the Constitution fundamentally protects a zone of privacy that comes from different amendments, including the Third Amendment, i.e., the Third Amendment isn't just literally about soldiers in houses, yes, no, up, down, vote, what can we do, what can we not do on soldiers, everything else is free game. It's just an example. It's illustrative, but not limited to the idea that we are possessed as people of this privacy right, which is a fundamental right, which has an outlet in some of the amendments, including the Third Amendment. So, what did Griswold hold on the next slide? Well, as they frame the issue here, you can see it gets right to it. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. And so this is particularly important. It's this idea in Griswold dealing with a law focused on marriage and that time's concept of marriage, but nonetheless that privacy cocooned, enveloped, protected that relationship. And the Third Amendment was part of the idea that the government can't intrude there. And so what the court said, and this is particularly important, is that we deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions. And so Griswold reversed, it struck the Connecticut statute, and fundamentally that right of privacy from Griswold v. Connecticut is in part rooted in the Third Amendment. So that's why I said in the beginning, we all get to use contraceptives in our bedroom and elsewhere, in part because of the Third Amendment. Go Third Amendment. Now let's talk about, outside the context of the zone of privacy, we're going to talk about property rights perspective and the construct of property rights and how the Third Amendment can be seen through a property rights prism as opposed to a privacy rights prism. This case is Block versus Hirsch, 256 U.S. 135 from 1921. And here, a landlord asserted that the District of Columbia's rent control statute, and this is a rent statute, was unconstitutional. And the landlord said this statute's unconstitutional because it authorized the taking of private property without due process of law. The statute, in other words, allowed tenants to remain in their rental property beyond the expiration of the term of their lease so long as rent payments were continued. And what happened here is that the court said the statute was not unconstitutional because its provisions were necessary to address public housing issues that came from a public emergency. And so, there's a public emergency, public housing problems, and so we can allow, if tenants are paying rent, you just can't evict them. They get to stay, and that's just the way it is for you as a landlord. And so here's the holding, and this is why it's particularly important. What it says is, in this amendment, there is plainly implied power in Congress to legislate as to the manner of quartering soldiers in a private house in a time of war. But with this exception, there's no restriction on the power of Congress not equally applicable in both peace and war. And it is not going too far to say that there is also a plain implication in this amendment that no civilian shall be quartered in any house in time of either peace or war without the consent of the owner. And so the Third Amendment then was interpreted to have this sort of plainly implied power in Congress, given this emergency to legislate about rent control and whatnot in that way, divined analogously from the Third Amendment. And so here again we find that the Third Amendment finds some life in the U.S. Supreme Court, but here it was through the property rights construct and prism, and that's the Block v. Hirsch case. This brings us to some modern Third Amendment arguments that are percolating, and they're kind of relevant to us because of the COVID and the COVID age and the vaccine rules and all the litigation melee that COVID has sort of brought to us in our lives. And so let's go back real quick and just recall the historical underpinnings. And you remember that the colonists were worried that quartered soldiers could infect them with a disease, smallpox, because the British soldiers, were actually intentionally moving smallpox around to wipe out the Native Americans. George Washington himself had smallpox. I'm not saying that he was trying to kill people, but he had smallpox himself in Barbados in 1751. And so here we have a University of Colorado at Boulder historian, Elizabeth Fenn, who said, quote, "Contagion was the defining and determining event of the era for many residents." In other words, smallpox was a big deal back then, and this was sort of the defining issue for people. And with the exception of the war itself, epidemic smallpox was the greatest upheaval to afflict the continent in these years. And for George Washington, smallpox, he said, it's more destructive to an army in the natural way than the enemy is by a sword. That's how big a problem smallpox and disease was. Now, here's what happened. Washington billeted some soldiers in the private homes of people in Morristown, New Jersey. And some homeowners had originally volunteered their houses. I mean, they were, rah, we need a revolution. We got to get rid of the king and all that. Then there's an outbreak of smallpox among the soldiers, and this creates chaos. And Washington had to order not only his soldiers, but also then civilians to receive inoculations. And so he did. And so we have actually some forcible mandated vaccines being given to, it's not vaccines, but in forced inoculations, in other words, to civilians and soldiers. The Third Amendment, therefore, we can see historically in this sense, it really is in two different ways, intertwined with disease. It's got, the ravaging disease of that day was smallpox. And so what we can understand sort of conceptually as a big picture then is that disease prevention and disease fear and disease paranoia and disease worry and, the spreading of disease, bizarrely enough, it's DNA intertwined, the double helix of DNA, the double helix of the Third Amendment. It's not just soldiers being in houses, it's disease in soldiers perhaps being in our houses. And so this is why it's particularly fascinating when we understand these historical underpinnings to see that the Third Amendment in its time is dealing with soldiers and disease perhaps. And so this then gets to the question on the next slide. Does the Third Amendment's protection have something to do with the right to be free from disease? The text, of course, doesn't mention it, but neither does the text actually mention a right of privacy. Griswold said it comes from the Third Amendment. So the question is, could the Third Amendment be interpreted to mean that there's a right to be free from being forced to come into contact with diseases? Think about that. So if that's the case, then judges could, through the Constitution, actually play a large role in managing disease, along with policymakers, the FDA, the SCDC, National Institute of Health, whatever, you name it. Our judges could actually be playing a large role in managing disease ultimately, if it's the case that the Third Amendment could be interpreted to mean that there's a right to be free from being forced to come into contact with disease. Now, let's see what's happened as we talk about COVID, Third Amendment, and what's happened. And, has anything been litigated? No, but have there been percolating issues and questions in legal circles? Yeah, actually, it turns out there have. And so we have the National Guard being deployed in our current time of civil unrest, and that's happened over the last couple of years, obviously. And so during 2020 and 2021, the National Guard was deployed heavily and quartered in hotels around the country. And many of the cities wanted them out, and cities started saying, wait a second, we have COVID going on, but we also just have all the protests going on in the country over our time's issues, obviously. And some of the questions that started getting raised is, we don't want the National Guard in our city. It's making it worse. We don't want armed forces here. We're in favor of kind of what was going on with the protests. And so questions were raised actually as to whether the Third Amendment has suddenly, out of nowhere become relevant again when National Guard members are being deployed and quartered in hotels. Could we start looking at the Third Amendment if we were a city as a means of saying, no, you're not going to quarter them in hotels, not going to happen, and we're going to make a Third Amendment challenge. Now, it wasn't raised, it didn't happen, it didn't get litigated, but we were on the edge of it. Now let's go back a little bit to police emergencies, and we're going to go to Nevada in 2015. Henderson, Nevada. We have some plaintiffs, the Mitchell family, and they filed a lawsuit against the Henderson police when the Henderson police came to their front door, battered the door open with a battering ram, and took over their home. And as they did it, by the way, they called the inhabitants a-holes, not, with the full word, obviously. And, the owner and his dog got shot with a pepper ball gun. There was a whole melee as they took over this home. And so the poor plaintiffs were like, what the heck? The police came in, they took over my home, they shot me, they shot my dog. And why did the police do it? Well, they wanted to secure an advantageous position in addressing a domestic violence report with a neighbor. And so the Henderson family, the family living in Henderson, Nevada, the Mitchell family said, okay, the police have quartered in our home, not in a time of war, in order to deal with some domestic violence dispute next door. And they filed a federal civil rights lawsuit. And one of the claims they brought, to address what happened, as well as having been shot with a pepper gun and the police battering down the door and all that, was a Third Amendment claim. And the question then for them became, is a local municipal police officer, if they overtake your home, are they a soldier for purposes of the Third Amendment? Not an incorporation question, a textual question. Are they soldiers, or are soldiers and police officers, even though they may perform similar functions in some way, are they actually different? What's the substantive reach of soldier? And the federal district court in Nevada, this is Judge Gordon on February the 2nd of 2015, said a municipal police officer is not a soldier for purposes of the Third Amendment. This squares with the purpose of the Third Amendment because this was not a military intrusion into a private home, and thus the intrusion is more effectively protected by the Fourth Amendment. And so the plaintiffs, although they didn't have a Third Amendment claim, they had other claims to deal with the problems that befell them, but they did try a very creative Third Amendment claim to say that what befell them was a violation of the Third Amendment. And here we have the case of the battering ram of the police to deal with domestic violence, not counting. Now, let's talk really briefly before we conclude about growing military surveillance in our sort of drone age, our robot age, biometrics, artificial intelligence technologies. They're all growing exponentially in this day and age. And so remember, if we go back to the Third Amendment, that National Guards dealing with a prison strike were soldiers for the Third Amendment. And so one of the questions that's been kicked around in academic circles looking at the growing military surveillance due to technology and the Third Amendment has been the idea of what happens when government agents, NSA workers, for example, are hacking our devices or our computers or our cyberspace for data. And this is occurring in our homes. Our home cyberspace, our home network is in our home. Government cameras or co-opting private cameras everywhere that are in more spheres that are capturing our homes. These questions raise the idea about whether the Third Amendment's relevant. And so here you have a quote from Stephen Fireland, wrote a law review article in the Wake Forest Law Review called The Third Amendment, Privacy and Mass Surveillance, again, from the Wake Forest Law Review. And here's what he said. The Third Amendment no longer will be the forgotten amendment if it is considered to interlock with the Fourth Amendment to provide a check on some domestic mass surveillance intruding on civil life, particularly within the home, business, or curtilage of each. In the digital age, the dual purpose of the amendment should be understood to potentially limit the reach of cyber soldiers and protect the enjoyment of a private tenancy without government incursion. Here's where I'm quite sure over the next 20 years of our lives, we are going to see, just given the immense technology growth that we're all familiar with, the hacking that occurs, the necessary involvement of government in technology, and what probably is inevitable in terms of hacking and monitoring and all that, where we're going in the world. We probably are going to see what Professor Fireland talks about, and that is Third Amendment being used to litigate what are cyber soldiers intruding into our homes and making arguments that you're quartering. You may not be quartering the way they quartered back then, but you're still quartering. And so this is another area. We have COVID, now we have technology, each of which perhaps are tripping over history and raising the ability to look at these questions again. So that brings us to the end today, and here are our conclusions as we deal with our Bill of Rights program for you, the curious lawyer. This is the least cited and least litigated amendment. There's a fascinating historical relationship of it to governmental intrusions. It formed part of the bedrock of the right to privacy in the Warren Court cases with Griswold, where the court rejected the state's ability to deny married couples the right to have sex with contraceptives. Very few cases to litigate it, but it has been applied to the states by incorporation Soldiers has been expanded to include the National Guard, but it has not been expanded far enough to include police. And finally, there's a fascinating relationship to disease and modern technology between the Third Amendment and it that could lead to interpretations in the COVID age and in the advanced technology age, where we start looking at whether the government can have cyber soldiers in our houses or not through our computers, or perhaps by co-opting Alexa or Siri. Thank you very much for attending today's Curious Lawyer Bill of Rights programs. Watch all our other programs. You can see all 10 amendments in time and have become like the expert at your next cocktail party. Thank you very much.